Under color of law, few phrases in American legal language generate more confusion, anger, and misunderstanding than the phrase, under color of law. Citizens hear it in civil rights lawsuits. They hear it during discussions of police misconduct. They hear it in documentaries involving wrongful convictions. They hear it in conversations about corruption, abuse of authority, and constitutional violations. Many assume the phrase means government officials acting illegally. That is not quite correct. The legal meaning is both broader and more important than that. A person acts under color of law whenever that person uses authority derived from government office, employment, or official position to exercise power over another person. The action may be lawful. The action may be unlawful. The key question is not whether the official was obeying the law. The key question is whether the official was using governmental authority while acting. The origin of the phrase. The concept emerged from the struggle to enforce constitutional rights after the American Civil War. Congress recognized a problem. If local officials themselves violated constitutional rights, who would protect citizens from the government? The answer became federal civil rights laws, allowing the federal government to intervene when state actors abuse their authority. Today, one of the principal criminal statutes is 18 U.S.C. Eccer 242, which makes it a federal crime for a person acting under color of law to willfully deprive someone of rights protected by the Constitution or laws of the United States. The law applies to police officers. It applies to jail personnel. It applies to judges under certain circumstances. It applies to prosecutors. It applies to correctional officers. It applies to public officials generally. Government power carries responsibilities precisely because government power is unique. Authority is different from force. An ordinary citizen cannot legally stop your vehicle and demand identification. A police officer generally can. An ordinary citizen cannot issue a warrant. A judge can. An ordinary citizen cannot sentence someone to prison. A court can. Government officials possess powers unavailable to ordinary citizens because society has delegated those powers to them for legitimate purposes. The constitutional system depends upon those powers being exercised according to law rather than personal preference. The badge, robe, office, title, and uniform all represent delegated authority. The danger arises when authority becomes confused with ownership. Public officials do not own their powers. They borrow them from the public. Acting under color of law does not mean acting illegally. This distinction is essential. A deputy sheriff making a lawful arrest acts under color of law. A judge conducting a lawful hearing acts under color of law. A prosecutor filing a lawful indictment acts under color of law. The phrase itself does not imply misconduct. Instead, the law asks a second question. Was governmental authority used to violate protected rights? If the answer is yes, a civil rights violation may exist. If the answer is no, the action may simply represent ordinary lawful government activity. The difference matters because public discussion often treats the phrase itself as proof of corruption. Legally, it is not. When authority crosses the line, examples of potential color of law violations may include fabricating evidence, knowingly making false statements in warrant applications, using excessive force without legal justification, conducting unlawful searches, knowingly withholding exculpatory evidence, intentionally denying medical care to prisoners, using official authority for personal retaliation, sexual exploitation by correctional staff or officers using official power. Federal authorities have prosecuted numerous such cases under civil rights statutes over the years. The important word in many federal prosecutions is willfully. Mistakes are not automatically crimes. Negligence is not automatically criminal. Federal prosecutors generally must prove intentional or knowing deprivation of rights rather than simple error or poor judgment. The difference between error and abuse. Suppose an officer arrests the wrong individual because two people share nearly identical names and birth dates. That may be a mistake. Suppose instead the officer knowingly falsifies facts to justify the arrest. That is entirely different. The law recognizes this distinction because human systems inevitably produce errors. The Constitution seeks to prevent abuse. Democracies can survive mistakes. They struggle to survive institutional dishonesty. Police officers are not the only officials. Covered public discussions often focus exclusively on law enforcement. The doctrine reaches much farther. Jail staff can violate rights under color of law. Prosecutors can violate rights under color of law. Public officials can violate rights under color of law. Correctional officers can violate rights under color of law. Even off-duty conduct may qualify if an official uses governmental authority or status to accomplish the act. The federal government and the FBI specifically recognize that misuse of official position outside ordinary duty hours may still constitute a color of law violation. The badge does not disappear simply because the shift ended. Georgia and official misconduct. Georgia law contains several statutes addressing official misconduct and abuse of office. Georgia law criminalizes intentional violation of an official oath by public officers and provides penalties for willful abuse of governmental office. Georgia law also recognizes misconduct involving oppression, malfeasance, misfeasance, or actions taken under color of office that improperly use governmental authority. These laws exist for an important reason. Government cannot police citizens effectively if citizens believe government officials themselves are beyond accountability. Public trust is one of the most valuable assets any institution possesses. Once lost, it is extraordinarily difficult to rebuild. Prosecutors and the duty to seek justice. One of the most misunderstood roles in the criminal justice system is that of the prosecutor. Popular culture often portrays prosecutors as lawyers, whose sole objective is winning convictions. Legally and ethically, that is incorrect. The prosecutor's duty is not simply to win. The prosecutor's duty is to seek justice. That includes pursuing valid cases. It also includes dismissing weak cases. It includes disclosing exculpatory evidence. It includes correcting errors when they occur. Georgia legal authorities and professional rules emphasize that prosecutors serve the public interest rather than merely seeking convictions at all costs. Most prosecutors take that responsibility seriously. The constitutional system depends upon them doing so. Hall County as a local lens. Hall County, like every county in America, relies upon public trust to function. Deputies, jail staff, prosecutors, public defenders, judges, probation officers, and court personnel exercise substantial authority over the lives of citizens. The overwhelming majority perform those duties professionally and lawfully. That fact should be acknowledged openly. At the same time, constitutional protections exist precisely because systems occasionally fail. Internal affairs units exist. Professional standards offices exist. Judicial review exists. Appeals exist. Civil rights investigations exist. These mechanisms are not signs of institutional weakness. They are signs of institutional maturity. The founders assumed human beings were imperfect. The Constitution was designed accordingly. Why the phrase resonates with citizens. Many citizens use the phrase under color of law in a broader and more emotional sense than lawyers do. They may feel the rules were applied unfairly. Officials were dismissive. Their rights were ignored. Procedures favored the government. Nobody listened. Those feelings may arise from actual misconduct. They may arise from misunderstandings. They may arise from poor communication. They may arise from lawful but harsh outcomes. The emotional experience should not automatically be dismissed. Neither should it automatically be accepted as proof of wrongdoing. A serious investigation requires evidence. Evidence protects everyone. Evidence protects citizens from abuse. Evidence protects public officials from false accusations. The rule of law depends upon that neutrality. Accountability protects honest government. One of the greatest misconceptions in modern politics is that accountability weakens institutions. The opposite is usually true. Accountability protects legitimate authority. The officer who obeys the law benefits when misconduct is punished. The honest prosecutor benefits when corruption is removed. The ethical judge benefits when public confidence increases. Citizens cooperate more readily with institutions they trust. Communities support agencies they believe are fair. Transparency is not the enemy of government. Transparency is one of the foundations of legitimacy. The temptation of conspiracy. When people feel powerless inside complex systems, conspiracy theories often flourish. Some theories surrounding courts and government institutions contain kernels of truth mixed with unsupported claims. People observe case numbers, financial penalties, bonds, fees, datos, contracts, budgets. They conclude that human beings are being traded as financial instruments. Some theories go further, alleging that judges receive payments tied directly to convictions, or that birth certificates create hidden financial accounts used by courts. At present, no credible evidence supports these claims as descriptions of ordinary American criminal courts. That distinction matters. There are real financial incentives in portions of the justice system: private probation contracts, jail telecommunications contracts, electronic monitoring fees, court fines, collection services, bail bond industries, civil forfeiture revenues. These documented economic structures deserve investigation on their own merits. They do not require unsupported theories to justify public concern. The Republic's central question. Every constitutional republic eventually confronts the same question: who watches those who exercise power? The American answer has always been the Constitution. Independent courts, free elections, a free press, professional ethics, internal oversight, civil lawsuits, criminal prosecutions, public scrutiny. None of these mechanisms are perfect. Together they form a network intended to restrain power before power becomes oppression. The system sometimes succeeds. The system sometimes fails. The work of a free society is reducing those failures rather than pretending they do not exist. The thin line. Government authority is necessary. Without it, there can be no courts, no public safety, no contracts, no property rights, and no civil order. But authority without accountability eventually becomes arbitrary. The line between legitimate authority and abusive authority is often thinner than societies realize. The badge and the Constitution are not competitors. The badge derives its legitimacy from the Constitution. The robe derives its legitimacy from the Constitution. The office derives its legitimacy from the Constitution. Remove those limits and authority becomes merely power. And power without limits is precisely what constitutional government was created to prevent. Global Robotics Corporation, Robert Colee.